My name is Siobhan O'Dwyer, and I'm delighted that you're here this morning for this talk. It's our second time to have our clients in, so it's delighted there's another good turnout today. The talk we'll be giving this morning is on the Multi-Unit Act 2011. Basically, the talk is a very practical interpretation of the Act. I'm not a legal expert, but we've plenty of practical experience of multi-unit development management and the things that happen in it. And so we'll be talking about how we see the practical effect of the Act applying itself to multi-unit developments, and how we'll be involved in the application of it and how it will benefit multi-unit owners. So it's not a legal interpretation if any of you are solicitors or anything like that. The Act is intended to be a legal framework for multi-unit development. It was extensively amended during its course of passage through the Houses of the Oireachtas. It started out as a bill in 2009, and it was intended to regulate management companies. But then as various parties got involved in it, it was amended extensively through all sorts of party submissions for amendment to incorporate far more extensive provisions in relation to the completion and construction and quality of the developments and the handover from the developer. So it ends up being a lot more, and it, as such then, ends up being a very complex piece of legislation. The Act seeks to address problems relating to the ownership and management of the common areas of both existing and new multi-unit developments, to facilitate fair and effective management of the bodies responsible for the management of such common areas, and to provide for related matters. And probably the third element, to provide for related matters, encompasses the far greater element of the Act. But we'll go through that. And then it came into operation on the 1st of April 2011. Probably to understand the Act a little bit better, you need to look at the background, what was missing, why was there a call for it, and a need for reform. And effectively, apartment construction only started in the late 70s, early 80s in Ireland. It was a new form of housing, and they built apartments, but in fact there was no legal framework for those apartments. And my understanding from a friendly solicitor is that the very first solicitor was asked to come up with documentation for the conveyancing of the apartments. He sort of scratched his head and said, well, there's no such thing in Ireland, there's no precedent documents available, we've no prescribed methodology, so I'll take down a conveyancing document for an office building, and I'll scratch out office and I'll put in apartment. And that sort of started off the first piece of legal framework. And it's as simple as that it's developed. So it was rather absent. There were limitations within the conveyancing documentation from that point onwards. It lacked proper consumer protections, in particular for the purchasers down the road if there were problems. The conveyancing documentation and the framework was very absent in relation to the completion of the development. And remember, purchasers were going in, handing over 100% of their purchase money, and then maybe into developments that were only partially constructed. So the process for completion and handover was important, but in fact it was absent, considerably absent in the documentation. There were no conditions to the handover. It was often done late, many years later, or in fact sometimes not done at all. And there was no compellability if people wanted the conveyance done, if they wanted to take control of their management company. So there were a lot of gaps there. There were limited regulations for the management company. It had a small list of requirements in terms of cleaning and securing the premises and maybe collecting service charges, but it was absent in relation to many, many other areas that it should have been provided for. And also it had no real power, but I'll go into that. There were, to some extent throughout Ireland, in all form of development, there are deficiencies in our planning and construction legislation in terms of a building inspectorate body, in terms of compliance with building standards, in terms of compliance with planning permissions and so forth. And that didn't not assist the problems with multi-unit developments. In turn, if there were problems with completions or defects in the developments, there was limited recourse through the local authorities in terms of planning enforcement. They didn't cover completion issues and snagging issues, so there was no municipal support there at all. The booming economy, believe it or not, didn't help the situation because, in fact, people lived with problems, decided, well, my apartment is going up 10, 20% a year, the defects will cost XYZ to fix, we'll just put together our funds and we'll fix them ourselves. And sure, look at my capital value has grown so significantly, I'll just sell on now next year and I'll have made my profit and go. So that didn't, it really obscured the problems for everybody. People had limited comprehension of apartment living. We didn't have a history. Our parents didn't live in apartments. We didn't know much about how best to run them and how best, what requirements they had and the contribution, namely, from the owners. The media tended to concentrate on horror stories of developers leaving, abandoning sites, of escalated service charges or overcharged service charges. And they really did fail to grasp the much deeper issues and problems that were going on sites. The service charges and so forth were very much the superficial problems at the surface level. There were much deeper issues going on. Public complaint stimulated a number of initiatives. The Law Reform Commission undertook some reports and ultimately drafted the bill in 2009. The Office of the Director of Corporate Enforcement, through a lot of pressure from complaints, also got on board and did an extensive report to help consumers manage their developments. And the National Consumer Agency also drafted up guidelines. A lot of these bodies I was involved in during the right back since 2006, we've actually been involved in all sorts of different pressure groups to try and get this legislation through. So that maybe gives you a little bit more of the understanding for the need. In terms of the Act itself then, the application applies to existing and all future multi-unit developments. It applies to all multi-unit developments with not less than 5 units with shared amenity areas or common areas. It also applies to mixed-use developments, i.e. developments that have commercial units maybe on the ground floor or an office building or so forth. It applies to private housing estates where there is a private management company, where it's a gated development. It applies in the same application to them. The general scope of the Act then, I've broken it down for simplistic purposes to 5 elements. Obligations for the compulsory vesting, the transfer of the common area. New obligations on the developer's part in relation to the completion of the development. New remedial mechanisms for dealing with disputes, and they provide the circuit court as having jurisdiction on all of those cases. New regulations on the management companies in terms of reporting to the owners. A lot more information is required under statute now to the owners in terms of service charges and the provision of sinking funds as well. The management company itself in the past was very much an empty vessel. It didn't really have any contractual relationship with the developer whatsoever. It just received in, like an empty vessel, it received in the development. That management company now has extensive powers for the first time. So that's the basis of the talk I'll give this morning. It'll be on the 5 elements, and just moving quickly. In terms of the obligation to transfer ownership, it's probably the most radical piece of the Act in that it sets down an obligation for the transfer of the ownership of the common areas in 3 different types of developments. Future multi-unit developments, it's to be done before any sale can occur. So the transfer will no longer take years, it must be done before the management company will have the beneficial interest or the legal interest of the management company before anybody moves in. In existing partially sold, and partially sold means 80% or less sold units by the 1st of April 2011, it requires that the transfer be completed within 6 months, being the 30th of September 2011. And in existing substantially sold multi-unit developments, which are defined as 80% or more sold by the 1st of April 2011, it equally gives 6 months for the transfer. So the government is very keen for all of these management companies to be transferred over by September 30th, 2011. It's interesting because when I said the Act is going to be complex, I mean, in existing developments, does the Act intend to mean 80% of those built or 80% of those planned to be built? Also, what happens to the remaining 20%? So there's a lot of questions in relation to how this will be interpreted and then applied. I'll just go into each of those a little bit. In future multi-unit developments, which really the Act provides extensive consumer protections for apartment purchasing and ownership in the future. That's if we have any future apartment developments with the state of our economy, but I'm sure we will. But the provisions for those future developments will be much stronger. The OMC must be transferred before any unit is sold. The transfer doesn't relieve the developer of his obligation to complete the estate. He retains the beneficial interest. And for those of you who are aware, the beneficial interest and the legal interest, when they merge, forms proper control and ownership. There is to be, probably another radical piece, is that there is to be a new form of contract between the management company and the developer. And that probably is one of the strongest pieces of consumer protection provided, because up till now the management company really had no act to collectively represent the owners. It had no right to collectively represent the owners. So, and of course, when there was problems, people turned to the management company and the agent and then discovered that actually the management company had no contract with the developer, whilst the developer had to hand in the common areas and the development into the management company. The management company had no right to receive it in any particular format or any particular conditions. Now, there is general legislation that says all development must be in compliance with planning permission and building control, but it wasn't, building standards, but it wasn't enforced and supervised. So this contract really gives much stronger contractual relationship between that management company. It requires the developer, the elements of the contract to be provided, or the requirements for the developer to complete the works, to provide a defect indemnity, which is a new element. It requires the first year's service charge to be disclosed in the document. So, you know, problems with people not being aware of there being a service charge or the amount of the service charge, and the onus on the developer to prescribe an appropriate level is also required. House rules, people don't know that, you know, that they're not allowed to have pets or so forth, so that's all disclosed up front. The form of apartment lease, the vesting declaration for down the road, and dispute resolution mechanisms, which this Act actually gives a lot of. Also, the management company is required to have separate legal representation. Very big radical step as well. And unfortunately, the poor old developer has to pay for that. But it will have separate legal representation. Upon completion, I'll deal with this later in detail, but there is a lot more prescribed requirements and conditions upon completion of the development in terms of the determination of completion and the conditions to that completion, which I'll go into later. In existing, sorry, I said that. In existing partially sold multi-units, it, as I said, it requires that that transfer be done by the 30th of September 2011. The transfer is subject to the reservation to the developer of the beneficial interest. In other words, the developer still has the right to alter the estate and to carry out his work, and if design requires it, he can, as he would today, alter the estate. And the management company is entitled to receive the same suite of documents as future developments, which I'll go into in detail in a few moments. The same applies to existing substantially within 6 months. But however, in this case, the conditions are unclear. The Act does not say that the beneficial interest is reserved to the developer. So we're wondering, does that mean, does that mean that the substantially sold developments, where 80% or more units or so, will not have the same protections as existing partially sold? So it's going to be tricky to interpret it. And the talk is that there will be a number of challenges in court on this before it's fully determined in its interpretation. At the end of when the extinguishment of the developer's beneficial occurs, he makes a statutory declaration that the legal and beneficial interests stand merged. And most importantly, that declaration requires the consent of the mortgagees or the owner as well. So that will provide for, in itself, a process. I don't know what's happening to my screen here. And just so the development stage is defined in the Act as the period which begins when the first unit is made available for sale and ends after the construction works and ancillary works have been completed. And interpreting that in practice on a site is going to be great fun. So just mention it. And the thought is that the formula to fix it will be similar to any construction contract, including an arbitration clause. That's what the Law Society is intending to provide. But, you know, we'll see how that works in practice. I wonder what's going to happen to my screen now. The most important element of the extinguishment of that beneficial interest is a schedule of documentation that is to be handed over by the developer to the management company. And it's quite an extensive schedule. There's some duplications in it, but a list of it is there is a requirement that the entire development is certified to be in compliance and in completion. As you know, at the moment when you buy an apartment, you get a document, an opinion of compliance in relation to your unit. But of course it has qualifications for anything else that is not yet built at the time. And people in Ireland don't fully appreciate often that qualifications actually mean exclusions. So the certificate you buy on at the moment really is limited to the apartment and the 4 square walls around your apartment. It doesn't provide provisions for the entire development or anything outside your door. A certificate confirming that any financial contributions for planning have been paid. The safety file, which, you know, in firms like here and with developers, we would get them, but down the country and in smaller developments, safety file is never handed over. As-built structural drawings and as-built service drawings. Obviously, the biggest impediment for any management company or management agent is finding out the source of a leak or finding out the source of how the mechanelec works in the building so repairs can be done efficiently and speedily and effectively. O&M manuals for the plant and equipment. The warranties and guarantees that are contractually provided to the developer will be passed over, transferred to the management company, which means that if there is a problem with the subcontracted work, the management company can go directly to the subcontractor based on those warranties, which will be a terrific improvement. Test records for drainage, water pipe and heating pipe work, a big step in the right direction, because at the moment the pipework systems are often not tested. People move into the apartment development and within no time the water starts to leak where there's loose pipework, and we end up with multi-unit leaks and a lot of damage and inconvenience to owners. That requirement there alone will be a huge improvement to the occupational enjoyment for apartment owners. A schedule of plant and equipment and the expected useful life of same is very important when, for example, we're working out the building investment fund and what's needed in the future and the lifespan of that equipment, and making sure we have applied for predictive and preventative monies and arrangements for it. The title document for common areas and reversions, often they're not handed over and no one knows where they go. And the stamped and registered counterpart leases, at the moment the arrangement is that the purchaser's solicitor gets it stamped, but often it's not sent back to the conveyancing solicitor, and then it's not handed over to the management company. If we're suing anybody for arrears of service charge, it's absolutely essential that we present the signed counterpart lease to the judge. Without it, we can't collect service charges. So it's a massive problem for developments where they don't get these documentations. And then the statutory books belonging to the management company. In today's terms, no development, I think, would have any suite of documentation like that. It will be onerous for developers to provide it for partially or substantially, particularly in terms of as-built drawings after the fact. I think a lot of this stuff will have to be negotiated with them. But in terms of new developments where they can be planned for right from the start, it will provide a far better housing model and a far better arrangement for management down the road. What happens if the developers fail to transfer by the 30th of September 2011? Well, it's not a criminal offence not to do so. However, the owners or any member can petition the Circuit Court to complete and transfer. And then if a developer fails to follow that order, then it is a criminal offence. So we don't expect an awful lot to happen by September. I think there isn't even an awful lot of talk in the media about the people's rights to transfers and so forth. And developers and everybody are still getting their head around the interpretation and understanding. It seems like a very short period, the 6-month period. Can apartments be sold in the meantime if the 30th of September passes and the transfer hasn't occurred? Our understanding is that yes, they can be sold, that people have good title to their property, but unfortunately we're told that the banks will more than likely not want to give a mortgage unless the transfer has occurred. So whilst you have good title, you may not be able to get a purchaser unless the purchaser is willing to pay in cash. So that may be the reason why there is a push or a drive to get the transfers done. Another element of the Act is the new remedial and dispute mechanisms, and it provides the Circuit Court as exclusive jurisdiction for any issues. And I think these provisions are to provide some sort of recourse for existing developments where there are problems, because obviously the legislation can't be applied retrospectively. Legislation generally can't be applied retrospectively. So I think these remedial dispute mechanisms are particularly aimed at existing developments where there are problems. An application can be made seeking enforcement of any obligation under the Act. Section 24, a unit owner in existing partially sold or an OMC is empowered to apply for a court order directing the developer to complete, that is, to complete unfinished work or to attend to defects or snagging, or to hand over the development. And of course, in the past, the management company had no such right, so this is a new step. Other matters that the remedial mechanisms may be used for is to sort out legal documentation and get a court order for their interpretation or voting rights. Fragmentation of the OMC into multiple OMCs, which developers may want to do down the road to assist them in development. I'm not too sure that it will be favourable to consumers, but that's to be seen. And the apportionment of funds, maybe where there's confusion over what's sinking fund and what's not sinking fund. And the court, interestingly, is really, the Act really encourages mediation, and there are much broader rules to that mediation, in the sense that normally if the judge, if everybody agrees to go to mediation and it fails, it just goes back into court. In this case, the judge will be entitled to a report from the mediator. So anybody who's not cooperating with who hasn't cooperated with the mediation, or costs that have been incurred in the mediation, the judge will be for the first time allowed to take all of those matters into consideration. So it is maybe which will help a speedy resolution of matters that at the moment either there's no mechanism or they take a long time. So just going in the pages are upside down. In terms of the management company, then I mentioned, sorry, I just have to catch up here. In terms of the management company, there are new rules and obligations. Whilst the management company is a more powerful entity, it also has a lot more obligations and responsibilities, and of course the directors of the management company as such. It goes through really in the reporting to owners. The OMC must prepare an annual report detailing. Now, obviously, in any professionally managed development with a board of directors, there's an annual AGM and an audit, but this is not happening throughout the country. So this puts under statute footing the requirement, as well as under company law, obviously. But the annual report must not just cover the income and expenditure as it does at the moment, but it really requires far more information under the assets and liabilities, the annual service charges, the actual sinking fund, the planned expenditure on maintenance and repairs, details of the insurance cover in terms of its adequacy, where it's covered, who, what insurance company, the arrangements for that policy. Fire safety details. There will be a requirement to assure the owners at the AGM that the fire safety arrangements, the maintenance provisions are in place and operating appropriately. And any contracts with third party in relation to third party transactions, they need to be disclosed. As we've been in practice, a member meeting must be held once per annum, 21 days advance notice. Meeting must be held within the reasonable proximity and at a reasonable time. We've heard of developments in Cork having their AGMs in Dublin, and things like that will not be permitted. And obligations in the MUD Act are on top of the standard rules, which are very onerous in the Companies Act. So it will be quite important to be aware of everything that's needed in the management company and that it's looked after. In terms of service charges, again, there are new rules. A scheme of service charges must be established from day one. Often we've heard again that the developments are set up and it's 3 or 4 years later before anybody's told that there's a service charge, and obviously there's already dilapidations in the development. So the cost to the owners 4 years later is going to be quite onerous and maybe prohibitive to catch up at that stage. So the Act requires now that that scheme be set up from day one. I might say that a lot of these are already in place with professional agents and well-run developments, but it puts a really strong statutory footing on the matters. The OMC has the right to set the initial service charge, the very first service charge, but thereafter it must be approved by all the members. And in practice up till now, it was for the Board of Directors' sole discretion to decide what the service charge is. Now the directors will decide it, but it must then go to the members to be approved. It must be calculated on a transparent and fair basis, and the basis of calculation outlined. Now, if in existing leases that's already determined, so it will be interesting to see how that's adapted in terms of existing arrangements. And the budget must outline details and categories of expenditure, and the Act actually sets down quite a lot of the primary expenditure headings. 75% of the members present or by proxy may disapprove the proposed service charge, and if they do, then the existing service charge remains until there's an approval for the new one. All owners are legally obliged to pay, including the developer in the case of unsold units. So we've heard that in the media and so forth, and in some of your developments where there might have been a bit of reluctance on the part of developers and certainly receivers now as well, to pay for the voids where there are completed sold units, and in some cases where it can be unacceptable is where those units are rented out but they're not contributing to the service charge. That will now all be outlawed. Every unit must contribute to the service charge. So that's a big change. There has been quite a lot of inappropriate practices there in relation to that area. The unpaid service charges may be recovered by the OMC as a simple contract debt, but nonetheless we're quite disappointed that there isn't more provisions. Arrears of service charge is becoming a more difficult problem for apartment owners. Of course, not ones in this firm, but in developments in general, particularly where landlords live abroad and where they might be multiple unit owners. And so they're really forcing the development to operate on a limited amount of money because of their non-payment. the service charges must not be used to defray developers' expenses, and that really refers to when the developer was in control of the management companies in the past. Maybe sometimes monies were used for expenses that were not really correctly management company expenses. Excess service charges may be diverted to the sinking fund. So often people will say, well, if the service wasn't done, can I have my money back? And obviously it's much better for the management company to be able to divert it to the sinking fund if it's appropriate. Proper records of expenditure for auditing purposes are required. Then, sorry, I've just moved on quickly. So the service charges will now at least have a lot more transparency and direction on how they are to be arranged. There's quite a bit in the Act on the sinking funds. It requires that there is a sinking fund established in the development for very specific purposes. The unit owners, including the developer for unsold units, must contribute to that fund. And the contribution shall be €200 or such other agreed sum agreed by the members. And that actually, right up to the end of the Act being passed, was or such higher sum, greater sum, agreed by the members. So there had been a cap that it couldn't be lower than 200, and just within a few weeks before the Act was passed, it reduced the wording to or such other agreed sum. But nonetheless, it puts clearly on the platform that sinking funds are extremely important in multi-unit developments, and the Act acknowledges that. The fund must be established within 3 years for a future new development, and within 18 months by September 2012 if it's in an existing development. And those of us in practice in estate management would be disappointed with that, because it's good practice internationally always to provide for the sinking fund from day one. But nonetheless, it is a step in the right direction, and it's a positive one. Contributions to the sinking fund must be held in a separate bank account, and the sinking fund shall apply to traditional housing estates which have an OMC. So obviously footpaths, lamping standards, gates, any sort of communal provisions in the development that might normally require long-term maintenance on a non-annualised basis. Also, those traditional housing estates will be required to have them. The management company in general, I said it had a lot more power, but equally in terms of new obligations, it requires that the name owner's management company must be in the title of the management company. And I think this is for down the road to facilitate benchmarking between one management company and another, and to be able to give data guidelines on how management companies are operated, or maybe what expenses should be, what should be charged and so forth. We certainly welcome it. Equal voting rights. One vote of equal value to each unit will only be permitted. So weighted voting and all of the problems that were occurring because of developers particularly having weighted voting will now no longer be permitted and will be absolutely outlawed. And in existing OMCs, greater voting rights may not be exercised. So in existing developments, the Act is very clear, where there are weighted voting rights, they may not be used. The Act actually seeks for their distinguishment, for them to be outlawed. And in fact, if anybody wants to use any voting arrangement other than one equal vote per unit, they must apply to the Circuit Court for permission to do so. So it's very strong on that. And the aim is to give the owners the rights and the powers to make decisions in a fair, democratic manner. No directorships for a fixed period longer than 3 years. Obviously, you're allowed to become a director, but you must resign and go up for re-election again at the end of 3 years. Directorships in existence for a term longer than 3 years must be extinguished, but again, they're validly able to go forward again for re-election. And a struck-off AMC may be restored within 6 years. Previously, that was 1 year. That's a big step for a lot of management companies have been struck off the register, and people will have problems selling their units. So the Act allows for a longer period, and in the past, quite a lot of irregular problems occurred because developers maintained control for the 6-year period, then handed over, and by that time the management company was struck off. So this allows a little bit more, and then with the 6-year being, in that terms, being statute barred as well. So it really allows for a better process or arrangement. And an OMC cannot enter into contracts for a period greater than 3 years, and I think that's aimed at our industry. They don't want management agents to have long-term contracts where no one bothers to review them or put them out to tender or seek that they are competitive. Obviously, a contract can be renewed after 3 years, but it just sets in place the process there for renewal. And an OMC can effect essential repairs on parts of the development, not in its ownership, which is a good step in terms of sometimes where defects occur and they really do need immediate repair. House rules, there's a lot of consumer talk about them, but actually all it does is set down that the OMC may make house rules, which already exist, must be consistently fair and reasonable, which in most apartment leases is what's prescribed, must be circulated in advance and approved by owners is new. Landlords must oblige their tenants to observe the house rules, and generally that's been in practice a lot, maybe not always applied. And the rules may make provision for the recovery by the management company of any reasonable cost in remedying, but we all know the first work would be identifying who caused the damage and then proving that they caused the damage in that recovery. But nonetheless, that's a step in the right direction. And the Minister for Justice puts in that they may make regulations concerning house rules, but unfortunately it doesn't deal with it doesn't provide the management company with any greater sanctions, and house rules actually are one of the most difficult issues in a number of developments where there's antisocial behaviour or vandalism, or not perpetrated by the owners, but maybe by their visitors or by students or whatever. So, so the Act kind of looks like it's giving new provisions there, but I think they're not really going to be of much value, unfortunately. So that is the talk, the outline of the general, our general practical interpretation of the Act. And just on a personal level, I'd say that it's great. It's very welcomed legislation. It's been outstanding for a long, long time. The remedies for existing and partially completed developments are good. It's a pity that there was a big cry from our industries and from the RIAI, the architects, from the 2 engineering bodies, from most of the professional bodies for a 5% retention of purchase monies to be held by until the development was completed, and that was objected to extensively by the government in power at the time. For all sorts of administrative reasons, apparently. But that is disappointing, and a lot of people would feel that that would have been a far better mechanism to avoid problems rather than providing mechanisms to resolve problems. There's no new means to collect service charges. The Society of Chartered Surveyors Ireland put in a number of recommendations for, and the IPFMA and a number of bodies put in recommendations for making it more, encouraging people more to pay their service charges so we wouldn't have to go legal on them, and they have not been provided for in the Act, which is unfortunate. The greater powers to the management company is terrific, because we as agents know that everybody turns to the agent and says, what can you do? And we say, well, your management company has actually limited contractual rights to do anything, but this is what we think we... And it's not a good platform for any starting relationship with any development of owners. The schedule of documentation I mentioned, that's handed over from the developer to the management company. It's a massively important platform, a requirement, for the management company in terms of future use and maintenance of the development. And the new mechanisms for disputes is really welcomed as well. Maybe a speedy remedy through the mediation will be less onerous and less risky, less costly for owners to avail of. My final one would be who will oversee the Act. who will administer it, who will supervise it, what regulatory office the Property Services Regulatory Authority exists down in County Navan. They have not yet been given their legislative power, but we are expecting regulation this summer and maybe to be in working in the autumn. We would think that that body should maybe take supervisory role of this act, but we're not sure that that's intended to be. Anyway, that is the end of my few words on Multi-Unit Development Act. Thank you very much. If there's any questions, Paul and Patrick and lots of people from O'Dwyer Property Management are here to help answer them. Thank you.
Can I just say, most of us here, I presume, are in the 80% completed and sold bracket. So a lot of that stuff just won't apply to us. I know you were just presenting the Act as it stands, but like from our perspective, we've got huge debtors, people who aren't paying their management fees, some of them never have. And yet now we're being told that we just have to put up the fees because of the sinking fund edict. And I think there should be some kind of something sent back to whoever's policing this act to say that, you know, people who have been left in debt by the developers and are in more debt because of non-payers can't be expected to suddenly magic a sinking fund out of the air when they're struggling just even to pay their bin charges. I think something should be presented to these people, because you can't just magic money out of thin air for a sinking fund which is on the never never when we're struggling to pay day-to-day debts.
Well, I agree. I think people that are here, by the way, are not all just from substantial. A lot of people are from existing, well-built, established 10 years ago developments as well. But I think you're right in that substantially and partially completed developments are very vulnerable. The legislation is not, no legislation I think can be made retrospective. There are provisions in it that help. How they'll help, and in each case, in each development, it's very different. And I think you just have to put your heads down, see what provisions are available to help with, and use them as best we can going forward. But they certainly are not the answer. I mean, the utopia situation is down the road with future new developments. And we have to welcome that at least as a step in the right direction.
Yeah, I take that on board, yeah.
I'd like to say it was a great presentation. If we could get a copy of it, it does summarise things nicely, because I have managed to nod off over the actual Act itself, unfortunately. But I do have a question with regard to our particular development. We're one of the 80% completed, but our common areas have passed to the control of a receiver. So do the obligations of the developer, I'm not entirely sure whether all of this utopian stuff also applies to partially completed developments, and we're again the greater than 80%. Do those obligations transfer to the receiver? And also with regard to, you can apply to the circuit court if they don't get transferred over by September 2011. Could we then ask, can you force the developer to hand those over to get that schedule of documentation in place if they don't do it? Because at the moment they wouldn't be in breach. But if you petition a circuit court to say, go and fill in this documentation, and then is it then a criminal offence to not complete that documentation?
There's about 3 questions there. The first one, the receiver does step into the feet of the developer. So in terms of contributing to the service charge and so forth, that obligation continues on from the date of their appointment. I think every development will have to be looked at individually. There seems to be no global answer. The circumstances in each case, we've been meeting with receivers and dealing with them, trying to get our heads around what are their obligations and what can we push forward for certain clients who are stuck in dilemmas like you have. But it does seem like they are as obligated as any developer to hand over by the 30th of September. And at least with a receiver, you have a live, active person, body there that you can apply pressure upon for the handover. In other situations where developers have gone missing and the development hasn't got a receiver appointed, they're actually in a weaker position, in my opinion. And thirdly, yes, the management company or any owner can go to the circuit court to seek resolution of any handover or completion issue, and that is with a receiver or a developer.
Okay, and if the developer hasn't completed the development to the planning permission and to building control, and we have sought enforcement and we've been granted enforcement notices, does the obligation to complete the development to the planning stuff then also pass to the receiver?
I think even if a solicitor was standing here, they would be avoiding the answer to that question. I really don't know how to answer you in this setting as such, because it's very specific to your development.
Oh.
Yeah.
And
Similar for ours.
Yeah.
And practicalities of trying to get a safety file or a not-built shrine at this stage is long since.
I think that the schedule of documentation, it will have to be negotiated, because if they don't exist and the developer's gone, we will have to negotiate as best we can and say, well, look, we'll take this, this and this. And a good professional management agent will know the absolutely essential pieces that we need in terms of the safety file and the O&M manuals and warranties and guarantees. We know what would be vital to your management company. We'd be pushing for that, and we probably would say, well, as-built drawings and as-built service drawings would be ideal, but we're probably not going to get them. It's just not going to be. I think even a judge won't make a receiver produce them. They cost an awful lot of money after the fact.
Well, this and this, I don't think you'll get one this or that from.
Sorry?
You'll get nothing in terms of the receivers on a practical basis. I don't see how it could happen.
Well, we're working with receivers, and we do expect to get a lot of documentation. You remember, their problem is their receivers, and their difficulty is verifying what is the documentation, where is it, what does it mean, which documents is what. So I think we will have to cooperate with owners, with receivers, to try and move forward the problems in some of those developments. And I think in developments where people are cooperating to find solutions, they will come out the best. You're going to say something?
Yeah, just when receivers are appointed, they're only agents of the developer. Now, the developer might be insolvent, and therefore, if you're going to sue by the receiver as agent or the developer who's insolvent, your chances of recovering legal costs are zero.
Mad. Yeah.
Mad, So you've got to be practical with the receiver and get what you can.
Yes, I think working with them is the most practical.
Is the receiver that duty to get into the bank?
Yes.
So the bank has an obligation.
The bank has no obligation in terms of the developer's obligation. The bank will tell you that they're at a loss, that they're a victim to the whole thing. They won't step in.
If there are costs around this, and I did note that you said that the developer should pay for the legal costs in the conveyancing of the owner's management company, does that cost transfer to the receiver? And the fact that there's legal obligations around this, does that bump the owner's management companies up in the unsecured creditors priority listing?
I don't think the management company is ever up on the creditors listing, because it's just way down the bottom. I don't think it's a secured creditor, and this is probably Paul's area.
But I think, certainly from what we're hearing from receivers, they're going to deem them as unsecured creditors, and you're at the bottom of the pecking order. I think what they're sort of saying is, as Siobhan mentioned, if they have files, they'll give you whatever files they have. They're not going to go through and say, this is this, come into our office, you can take them away. They're of no use, but they're really into a position of whatever assets they have, if they're appointed over, they're looking to come in, dispose of them, pay back the banks, and exit as quickly and as cheaply as possible. And that seems to be the message coming back. I think where there's developments where, they're 50% complete, they may be dealt with differently in the sense from a practical perspective, in banks to get value back that they may take on some, further completion works or whatever. But as Siobhan said, I think it's got very much a case-by-case basis depending on the circumstances in the development.
I suppose what we were thinking as well was these documents that we were looking for did exist, but they were being kept from us. In which case the receiver wouldn't bother about that, because the receiver's an intermediary, and the receiver would give us the documents where the developers had not wanted to give it in case it led to them being taken to court or whatever for not finishing a development. But I mean, if they've gone into receivership, they can't be forced to pay for anything. So, like, why wouldn't they surrender the documents? It shouldn't be that hard.
I don't think it's, I think generally it's about they're gone, you know, and not the persons and the principals are gone, and no one knows where the documents, and our job ends up being trying to get someone to focus on where are the documents so we can go sit down, go through them and arrange with them that we'll take them over. So it's kind of, you know, it's being practical really rather than availing of any legal rights. And that's unfortunately going to be the way.
I think the Act's going to help people in the future more than it's going to help.
Oh, absolutely, yeah. I mean, it is, in a way, it is an admission of how, you know, inappropriate the consumer protections were in the past. But, you know, we have...
Might this be used as a mechanism, let's say, in future for developers, let's say unscrupulous developers, to actually, let's say, get out of some of the obligations of this Act, that actually, right, they'll develop a development so far, collect the monies so far, and then when it comes to, you know, handing over documentation and all the obligations of the Act, next thing they fold the company and put it into liquidation or receivership. You know, like your point earlier on that maybe there should be retentions or even a bond given to the management company.
Yeah.
You know.
Your question brings to mind in the government the night the Act was passed. I watched it on the video that you can see into the Houses of Oireachtas, and Pat Rabbitte said that it was extraordinary in Ireland that our government had a cultural inhibition about making builders build correctly.
Yeah.
And I thought really that summed up the nature of the past in Ireland, and maybe this is some sort of a step towards improved. I mean, there's a lot of things going on now. In addition to this, the Law Society are working on prescribed documentation. The engineering bodies in the RIAI are working on the sort of form of certification for the completion and compliance. I think the Act has already dealt with the parties who would do that. Now, it's all for future developments. But, and there's a big drive and acknowledgement through these circumstances that planning permission and building control is not sufficiently supervised in Ireland. That we don't have a statutory body, that self-certification, which is our methodology, doesn't work here because we don't have an inspectorate body. So I think, you know, if people are more aware, then there could be more lobby groups and pressure groups. But unfortunately, it's quite complex to understand. And most apartment owners want to just live in their apartment. They don't want to be
well, like if
dealing with all of this.
If a builder is going to build for the government, they'll actually have to give a bond to the government. So if the builder goes into liquidation or whatever, a bond company will step in, a bank or an insurance company. So that will make good any, let's say, increased costs that the person will actually incur as a result of that person going into. It's amazing that the government will look to protect itself, but it won't look to protect, you know, people in a situation like that. Yeah.
I spoke the very first time I got a platform to kind of highlight what I saw as the problems. I didn't know what the solutions were, but it was back in 2006 at the National Housing Conference, and through Pal, who was president of the RIAI at the time, asked me to get up and talk about it. And I highlighted that why was it that in Ireland, in public development, the local authority mandates a very onerous retention arrangement and bond, and that it is not released until every element of certification is verified. So in effect in Ireland we have far better, superior development in our public buildings.
Yes.
Local authority apartments are better built than in often cases than a private apartment schemes, which really is your point, and it's very true. And there should be, if people understood, they should be demanded, because multi-unit development in itself is very vulnerable to the absences there, because in any other form of development you have a client, you have a bank, and you have an arrangement that nothing is handed over until everything is ticked off. And whereas in multi-unit development your situation is very different. People hand over 100% of their money, move in, and then are at the behest of the professionalism of the developer. And I might add, there are a number of professional developers who would want to finish off. And they are actually at a loss. They're doing more in their development than the fellow down the road. And when we pursue them and say, look, we should put a second set of doors there, or we need a better locking system there, or those gates are inferior and we need better gates, or whatever it might be, or better motors, we negotiate with them and they go, well, you know, you wouldn't get this down the road. And that shouldn't be the arrangement. We shouldn't have to negotiate. You know, there should be a prescribed methodology. So,
you mentioned the Property Services regulatory body, and I presume that's going to be the regulator who's going to be, let's say, over management agents and all that. And fine, and I know, let's say, there's a number of unscrupulous management agents out there and all that, but and they are going to be in maybe trying to sort those out. But could there be a two-way mechanism there where, let's say, problems in the industry can be given to this regulator, you know, such as this issue with receivers and all that, and say, look at, and let's say the other one, the very important one you mentioned about debt collection, where they actually didn't really address the problem there. Like, could it be a two-way street that rather than lobbying that this guy would be, or this body would be giving, you know, a number of issues, saying these are key issues in the industry, you know, both for management companies and management agents to resolve, and that, you know, that they would actually maybe liaise with the government or whoever the legislature.
I mean, I think our general view is, and Paul's involved in the IPFMA and I'm in the Society of Churches of Various Ireland, and both of us are on committees and so forth. And I think that through those bodies we will put in more applications recommending further policy on different elements. And certainly the service charge one is the one that's most urgent. And the culture seems to be in Ireland to nearly protect the fellow who owes money to a landlord or a management company, and that has to change, because the victim of all of this is the other owners who are paid up.
It'll have to change, because even in the future with the utopian new developments, if you don't enforce the paying of the charge, you're not going to be able to maintain the sinking fund. It's just going to be the way it is. They'll have to do something about that.
So Siobhan, what practical steps do you see that could be done through a body like that, and what are you lobbying or advocating for?
Well, there are measures. For example, maybe a lot of the debts that are outstanding sometimes are owed by investors. But Paul would be better at.
Yeah, I mean, the suggestions that we're I mean, a lot of the trouble can be with investors, normally the owner-occupiers use a much better collection rate. So there was suggestions such as, you know, that you would get your tax allowances and your investment properties unless you could demonstrate you paid the service charge. Mortgage interest, again, you know, would be linked to the payment of service charge. They were very practical suggestions that went forward.
So there'd be a motivation.
I think the other area, I mean, there is an obligation within the Act that the owners have to provide the management company with their correspondence address. So one of the big areas of cost is when you are pursuing someone is serving those proceedings, because you have to do, if they don't collect it by registered post, then you have to serve, you know, so you have to get an inquiry agent out to find out where they were. So if you could have a scenario where you could actually serve on that correspondence address, like they do for, you know, in businesses where you can serve to the registered address, if you could just serve by regular postal address, you know, that would take a huge amount of the administration and cost out of it. So there are sort of some of the practical things that could assist us. You know, we have been, you know, any chance we have got when we've met with people, you know, I think it's really becoming apparent. But I suppose in the whole environment, there is a little bit, as Siobhan said, where it's a landlord-tenant, even though the judges might see it that way. You know, it's not owners, they just say, oh yeah, it's a management company. It's a bit like a bank and an owner. So that sort of psychological thing needs to be changed.
But we know in other jurisdictions, like for example in Finland, we had a very interesting debate with some Finnish people who were involved in developing new legislation for management companies. And over there, the management company has the right to go in and seize the apartment. and, you know, like literally take ownership of it. And that, of course, never happens because no one ever doesn't pay their service charge because the consequences are so onerous that everyone pays their service charge. So,
but I think that's also the case in France and Spain, because I was reading an article last weekend that in some of these places like Spain, that's where the owners have sort of left and they're not paying service charges, and a big problem down there as well. They said they just, in the end, just take the apartments back.
yeah, well, there's a forfeiture clause here in Ireland in our existing leases, but you go into court with it and you'd never get it. I don't think it's ever been applied.
I've tried.
Have you?
Mm-hmm.
There you go. I let you.
Do the management charges not accrue against the apartment so that it is ever sold?
Oh yes, I mean that's the one good thing in Ireland is that the debt belongs to the unit.
And
So,
is
you
the
know,
interest quite penal in a lot of cases?
Well, it's not that penal, no. I mean, it should be a lot more penal, I
It's
think.
pretty penal down Spencer Dock.
Well, it depends on the lease.
It's higher than the AA rate.
Yeah.
It depends on the leases, but in most of them it's only
Yeah, I mean, certainly,
1% above.
certainly, if you collect it in, its value in it is generally 3 or 4% above your LIBOR rates or whatever's in within the lease. It depends. But yeah, it is penal.
But I presume whether it's a developer or an investor, it's eventually going to have to come in. Because once
Yes.
the unit eventually gets sold.
Yeah, but it requires the unit to be sold. And no purchaser is going to take on the unit, you know, through the requisitions process on, you know, if there is an outstanding debt. So it will be usually settled through the proceeds or whatever.
So the second thing of that is if the solicitors they do that, they won't do a conveyance until the charge is up to date.
Yeah.
If a developer is selling it, or if a receiver on behalf of a developer on behalf of a bank is selling an apartment, our solicitors looking at the conditions in months of it now saying, well look, not only is this developer behind in this apartment, he's shortly lacking in the overall fund of the management company. I mean, our solicitors saying, look, I've sorted out.
I don't know. I mean, you're talking about the solicitor acting for the purchaser.
Yeah.
And you're asking him to probably do a lot more work in his investigations than he might for his €500 fee for
Yeah, but the
conveyancing.
purchaser could be buying into something that's seriously.
The purchaser, I think, should be extremely scrupulous in any apartment that they're buying
Or
to
the purchaser
investigate
solicitor.
what they're buying and the arrangements that are going on there.
But
And
is,
I think as well as that, Barry, in requisition 37, which is the replies we give, it would be put in there if there is debts owing by the developer. So you're trying to make the purchaser solicitor aware of the issue.
Yeah, like we do our best in the replies to recommendations to highlight that there is money owed and that the transaction can't get through until these are paid. And that's usually where our collection point is very successful. But like apartments might sit there and not be sold for a long time now. And that's the problem.
When one person owns 7 apartments in a development and they manage to sell one of them, when you reply to that requisition 37, do you tell the intending purchaser of a single unit that the developer or the multiple owner has to pay all arrears for all apartments, or do you just refer to particular apartments?
I think we use every legal methodology permitted, including, you know, if there's an insurance claim, we won't pay out the settlement monies on if there's any arrears owing. But you know, there's, in the new media, there's been talk about clamping cars and turning off electricity and things like that. And we haven't been involved in that. And you know, we've got a pretty successful rate in our service charge collections. But I do think in other countries you would be permitted to turn off the electricity. You know.
Yeah, and I think certainly from discussions with the regulator, he would be would not favour any of those sort of mechanisms. He's going to come very strict on that, is what he's saying, and that it's very much you have to go through to debt, you go through the legal process for collecting it.
Sorry, who's saying that?
The regulator.
The regulator.
And the regulator, please.
Well, it will be. He hasn't. This is the
Tom
Tom Lynch, who's the regulator. He's sitting down in NAB, and he hasn't been empowered yet. But he's indicated he will be empowered by the summertime.
July.
Yeah.
But the regulator, remember, is regulating us, the management agent industry, and the estate agents.
not regulating us.
He's not regulating management companies. It's very clear when we say, could you put in this provision and can you mandate this and can you supervise it? And he goes, no, I'm not doing that. That's outside of our remit. Because we've been lobbying for, I mean, we're lobbying as well for that office to have supervisory policing of this act as well. Somebody will have to, or otherwise it won't be necessarily as effective as intended.
And again, there's the regulator doing the typical Irish thing, sitting back saying we're not going to, you're not allowed to punish these people, you're not allowed to encourage them to pay in any way, you just have to wait for them to decide what they might want to pay.
Well, this is where I think that, you know, the lobbying, and I think we need more than just, you know, obviously from age, I think we need, you know, owner directors, you know, so they're hearing it from people who are actually affected by it.
Yeah.
And that's going to be maybe trying to get someone, a body, a group that will make representations from owners or directors of management companies to say, well, this is a real problem, or becoming a real problem.
So is it appropriate that the regulator regulates both the management company and the management agents? Is that,
it's a body that would be familiar with the process, whether it's appropriate. We just want a body. To be honest, we don't mind who it is, as long as they're active and interested and they're appointed.
But if this act is useless if there's no policing?
Well, it's not useless, no. The Act has very strong provisions, and ultimately, if they're not applied, you can go to the Circuit Court and get an order for them to be applied. So we welcome the legislation. It isn't perfect, but it is a big step in the right direction. And so it's unfortunate that it doesn't retrospectively provide as much for existing and substantial. But when the Act was being drafted, it was drafted before the downturn. You know, the added complexities of unfinished developments and developers gone out of business has made it just even more, highlighted maybe more its weaknesses, but that is just an unfortunate set of circumstances.
Do you think more could be done? You talk about the psychological thing that people not paying service charges perhaps think that they're just getting one over on some big institution. Could more be done to publicise the fact that it is actually your fellow neighbours who are suffering?
Well, I think the Act again is absent, and it's been admitted by government and by the guys that actually wrote, you know, very heavily, the senior civil servants were heavily involved in the prescription of it all, that the Act fails to address education and the absolute role that education has to play in all of this. And people buying into apartments, they must understand that they bought into a community. It requires involvement, it requires all sorts of obligations and rules and regulations, and that it's not simply, oh, I bought my apartment and that's it, no more further investment.
Well, I think I would presume before I got into this that it was the management company taking the hit if someone didn't pay their service charge. And I imagine probably quite a lot of people in the public who just assume that they're, you know, they're getting one over and they're rationalising.
Yeah, well, we often get people who come on boards or committees and they're very anxious and, misunderstandings like that, and then they become aware, and then, oh my gosh, they didn't know all of this, and that's shocking to observe. You know, people should be much more aware before they buy, and we would be mandating and pursuing for more information from the estate, the role of the estate agent, the role of the solicitor acting for the purchaser, that they would have a much bigger role in providing information.
I mean, I think one of the problems is the media have tended to focus in on the problem areas, you know, and it sort of exacerbates the problems. You know, people say, oh, well, sure, like, there's a real problem out there, we're not paying into that version. They ran some positive stories on the importance of
how they work when they work well.
You know, and we've been trying to give, you know, ask them to write articles, and there's little interest, to be honest.
Sorry, in the interest of people who haven't been paying up, and this is something, Paul, that you know is a matter near and dear to our hearts, there's also a requirement for management companies to publish accounts. Now, how detailed do those accounts have to be? Because we've been wondering, can we name and shame people who don't cough up? And if we were to do, these are our suppliers, these are our creditors, and these are our debtors, in more detail than we've been providing, we're not naming and shaming, we're just providing information. Is that allowed for in this Act?
Well, I mean, I think you have to be very careful. I mean, again, I'm not a solicitor, and it's always, but the legal advice that we receive is naming individual debtors can be troublesome.
Oh, I understand that, but now I see that I have a legal obligation, or that the management company has a legal obligation to publish their accounts. So how detailed do those accounts have to be?
Well, I suppose, if you take a statutory set of accounts, they don't disclose who each individual creditor, they don't do each individual debtor. I mean, it's just statutory headings. So, I mean, you're going beyond that. And I suppose that's where difficulties will arise.
Is it possible to say, well, okay, there are so many that money is so many, maybe not name and shame then, but highlight that there's 10 apartments and the apartment 1 is this, apartment 2 is that, apartment 3, not numbers, say the top debtor apartments wise owes so much over so many years and so on, and break it down. And then if somebody wants to go to ye and ask for that information or whatever, but maybe highlight that, is that a possibility?
I think, the directors can do what they want. They can instruct what they want. I mean, if they get their legal advice and they're happy with it, as a managing agent, obviously we're not in a position to say.
Can you not publish the people who judgments have been given against? Like, is that not in the
public
domain?
Yeah, I mean, they do it in irrefutable anyway. If you've got
but can I mean, because everybody isn't going to go through that and whatever, but like, let's say even the directors or whatever, can you not just maybe publish a list and say, here's the list of members who judgments have been registered against in your management company? And I know you can say it's naming and shaming, but it's information that's in the public domain already, if people went to the bother of actually looking for it. But is there a risk, is there anything illegal in doing that? Or, just as a matter of a mechanism of actually trying to get people to actually pay.
I'd have the view that publishing names that have judgments against them would be all right. I think before that, publishing just people who are owing at year end could be very risky for the management company and the directors, because if there was a mistake, or if the debtor had actually paid on the night before, or had paid to somebody, another party, or there could be all sorts of circumstances that could expose the directors of the management company to legal action.
Poor tenants, or just
normally up at the gatepost at the entry point to an apartment development. Yes, it is. That's a name and shame process to try and encourage it, but they're still in arrears in Spain. It doesn't actually solve the problem, to be honest. But it has an added, it has a bonus factor somewhere along the way.
Yes, I still think that it would help.
But the problem is defamation laws. And get around just once, and it won't have been worth it. Just won't have been worth it. It's as simple as that.
I also think a lot of the large investor, landlord, debtors that we see sometimes repetitively in different developments, they would not be bothered by their name being up or anything like that. It would just not have any effect on them. Or where they're living abroad and they have no personal relationship with the development, it wouldn't apply. Also publishing, highlighting that some people don't owe, sometimes discourages the payers. They say, well, if they're not paying, I'm not going to pay. So that also is
the other side is, if you go into an apartment block, there's 20 apartments, there's a notice board there, and you have a list up there, and block number 3, number 7, number 10, owned by so-and-so, and here's a judgment registered against them. I still think that people, and if you know that neighbour, if it happens to be owner, an owner, fine, but the tenant won't particularly be that impressed either that he's paying rent and his landlord isn't paying towards the maintenance of the common areas, or let's say that the corridors aren't kept clean or whatever.
Well, the resources required to do that, also then it's unreliable. I think you might find that tenants tell you that you're impinging on their privacy, or I think you'd have also some problems applying that in reality. I mean, we do know that people are trying out all sorts of things to try and get the money in, particularly where it's very brazen withholding, and some methods are working. And I think most importantly is to get off to a fast start. I mean, putting everything in the envelope, like in our own firm, the budget, an explanation, a breakdown, and all of the detail that any owner, and then as soon as somebody brings up with the query, addressing that query, and not giving any excuse right from the beginning for non-payment is pretty important in the scheme, because you want to be, if they are going to be a non-payer, you want to know that within month 4 or 5. You don't want to find it out in month 10 or 11. So that process of providing information is hugely important right from the start. And I think that's probably why, I don't talk about how good our firm is, we're struggling with debtors too, but that is hugely important. And I think this Act provides for people to be given a lot more information in developments and put statutory footing on that, and that will help a lot of developments. Because people are genuinely not paying because they don't know what they're paying for. That's not an unreasonable response. It might be unacceptable, but it's not unreasonable.
And maybe in the state, which is mainly owner-occupiers, but we're currently in the process of validating the list of every single individual to make sure that's the right name, that's the right amount of money. And then our next step is doing a common letter to everybody saying the following names have not paid their charge and this is how much they owe. We made a decision to get on with it. In a name and shame.
In a kind of peer group pressure type thing. Yeah.
To be checked with the PRTB as well, because they should be registered, whether you can see generally who is registered with PRTB in case we were rented, in case it changed.
So equally, there's 15 that we know of.
Sorry, Siobhan, just on, you mentioned about the sinking fund being in a separate bank account. Now, is it the case that, let's say, funds collected to date would have to be in that separate bank account? I'm just talking about like situations where companies are getting into difficulty. They can't now dip into the sinking fund for their day-to-day service charges. So then what they end up having to do is levy the members more for the non-payers and all that. But let's say in a situation where a company has funds already in the sinking fund, must the funds already be put into that separate bank account?
Well, it's not retrospective, so it's only for charges levied after the 1st of April.
Right, yeah.
So for any sinking fund collected after the 1st of April or levied after the 1st of April, we'll have to go into a separate bank. That's black and white. So historically, not all, you didn't have a cap, there's monies, if you were using monies to subsidize current sort of expenditure, historically, ideally you wouldn't do it, but if it hadn't done, well, that's historic, but it's only a go forward.
So you'll only have to have a separate bank account for new monies collected on the sinking fund.
I'm realising we've run over our time with you all, we have engagements to go to. So if anybody would like to stay, if you've still got further questions, we're more than happy to hang around and chat to you all and have another cup of tea. And in the meantime, thank you very much for coming in. And thank